The title of today's topic is Rights of Detainees under the Indian Laws. Let me have some introduction. When a person is in custody and his or her personal liberty is taken away, except as a result of conviction for an offence, he or she is said to be in detention, and such a person is called as a detainee. Such detention may be required either for securing the attendance of the person at trial or to prevent the commission of a crime. In order to protect the human rights of a detainee and also to prevent a violation of human rights of the detainees by law enforcing agencies, numerous important safeguards in the form of fundamental rights are provided in the Constitution of India. The Criminal Procedure Code of 1973 also contains similar safeguards. One of the most important fundamental rights enshrined in the Indian Constitution is Article 21, which states that no person shall be deprived of his life or personal liberty except according to procedure established by law. Since arrest and detention will deprive a person of his or her personal liberty, it should comply with the provisions of Article 21 of the Constitution. The term detainees can be applied to two broad categories of persons, namely, number one, those detained by police waiting to be brought before a magistrate on formal charges or awaiting trial and unable to secure bail. And number two, those detained under specific preventive detention laws. Important rights of detainees are discussed under the following heads. Rights of pre-trial or under-trial detainees. The police have been given various powers for facilitating the making of arrests and detaining individuals alleged to have committed crimes. However, the powers of the police to arrest and detain a person are subject to various safeguards provided in the Constitution of India and the Criminal Procedure Code. These laws zealously protect the interests of detainees by recognizing as rights of such persons. Thus, a person can only be legally detained in specific circumstances established by law. The procedure that must be followed to detain any arrested person must be right, just and fair, and not arbitrary, fanciful or oppressive. The rights of pre-trial or under-trial detainees are: number one, right to know the ground of arrest. As provided under Clause 1 of Article 22 of the Indian Constitution, an arrested person shall not be detained in custody without being informed as soon as may be of the grounds of his arrest. The persons being arrested should be informed precisely of the act done by him or her that has constituted a crime, not merely the provisions of law that he or she has allegedly violates, that too in a language which he or she understands. The right to know the ground of arrest is a precious right of an arrested person because it enables him or her to move the proper court for bail or to make expeditious arrangements for his or her defense. Similarly, the Criminal Procedure Code also recognizes the right to be informed of the grounds of arrest as provided in sections 50, 55 and 75 of the Code. 2. Right to be defended by a lawyer. Article 22 Clause 1 of the Constitution also guarantees that no person who is arrested shall be denied the right to consult a legal practitioner of his choice. In other words, the arrested person should be informed of his or her right to have access to a lawyer of his or her choice. Similar provision is provided under Section 300 of the Criminal Procedure Code, which states that any person against whom proceedings are instituted under the court may be defended by a pleader of his choice. This right begins from the moment of his arrest. If the detained person cannot afford a lawyer, he or she should be informed of his or her right to free legal aid, which means that he or she will be provided a lawyer to defend his or her case at the expense of the government. 3. Right to be produced before magistrate. Article 22 Clause 2 of the Constitution expressly provides that every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of magistrate. It is also provided that such person shall not be detained in custody beyond the period of 24 hours without the authority of a magistrate. The sections 57 and 76 of the Criminal Procedure Code also contain analogous provisions. The arresting authorities must produce the arrested person, whether the arrest was with or without a warrant, before the magistrate or court within 24 hours time. 4. Right to be examined by a medical practitioner. Section 54 Clause 1 of the Criminal Procedure Code gives an arrested person the right to have him medically examined to enable him to defend and protect himself properly. The magistrates must inform the arrested persons of their right to be medically examined in terms of Section 54 of the Code, otherwise they will not be able to exercise it due to ignorance. The medical examination of a female should be made by a female medical practitioner as provided under Section 53 Clause 2. 5. Right to be released on bail. Section 50 Clause 2 of the Criminal Procedure Code provides that where a police officer arrests without warrant any person other than a person accused of a non-bailable offense, he shall inform the person arrested that he is entitled to be released on bail and that he may arrange for sureties on his behalf. This helps those persons who may not know about their rights to be released on bail in case of bailable offenses. 6. Right to speedy trial. The courts have recognized the right to speedy trial under Article 21 of the Constitution. It is not uncommon in the country for those who are detained to spend 4 or 5 years awaiting trial for a crime when they would have served a much shorter sentence had they been convicted. 7th. Right against self-incrimination. Article 20 Clause 3 provides that no person accused of an offense shall be compelled to be a witness against himself. Thus, the accused person cannot be compelled to give evidence against himself by threatening, beating, or injuring him. Rights of detainees under preventive detention. Preventive detention is the keeping of a person in custody, normally in jails, based on a suspicion or reasonable apprehension that the person will commit an illegal act. The object of preventive detention is to prevent a person before he commits a prejudicial act. No offense is proof nor any charge framed against such person. In Western countries, preventive detention is used in war times, but in India, it is used in peace time. There is a multitude of preventive detention laws in India at both the central and state levels, like the National Security Act 1980, the Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act 1980, the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988, etc. To prevent misuse of the power under preventive detention laws, the Constitution of India has provided certain safeguards in the form of fundamental rights of a person who has been preventively detained. Clauses 4 and 5 of Article 22 of the Constitution of India provide the safeguards. Thus, a detainee under preventive detention laws has the following rights. 1. Right to be reviewed by advisory boards. Article 22, Clause 4 of the Constitution states that no law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months unless an advisory board constituted of persons who are or have been or are qualified to be High Court judges has reported before the expiration of the period of 3 months that there is, in its opinion, sufficient cause for such detention. A detainee has thus a right to be reviewed by an advisory board of the detention order within 3 months of preventive detention. If the advisory board reports that the detention is not justified, the authority is duty bound to revoke the detention order. Number 2, right to be informed of the grounds of detention. Article 22, Clause 5 requires that the grounds of detention must be communicated to the detainee in the language known to him. The detainee must be supplied with the documents on which the detention is based, and any delay in supplying these documents results in setting aside the detention. Number 3, right to make representation. Article 22, Clause 5 also guarantees that a detainee shall be afforded the earliest opportunity of making a representation against the detention order. In order to enable him to make a representation which on being considered may give him relief, he should be furnished with sufficient particulars of the grounds of his detention. Such a representation should be considered and disposed of as expeditiously as possible. The appropriate authority should exercise its fair consideration on the representation before sending the case along with the detainee's representation to the advisory board. Now coming to judicial trend, the study of rights of detainees will be incomplete if we ignore the role of judiciary. The Indian judiciary has given paramount position to the right to life and personal liberty. The Supreme Court of India, while interpreting Article 21, has held that life meant more than mere animal existence. It includes right to live with human dignity, right to the basic necessities of life, and also the right to carry on such functions and activities as constitute the bare minimum expression of the human self. The courts have recognized the right of the detainee to have interviews with members of his family, friends, and his lawyer, and even to write a book and get it published. Further, the Supreme Court of India and the High Courts have power to issue the writ of habeas corpus under Article 32 and 226 of the Indian Constitution respectively. By this writ, an order is issued to a person or a jailer or a district magistrate to produce the detainee before the court and justify his detention. If there is no valid reason for detention, the court will immediately order the release of the detained person. But it cannot be granted when a person is committed to jail custody by an order of a competent court. The writ of habeas corpus assumes great importance in view of the protection of personal liberty of a person. Many a times, petitions for issue of writ of habeas corpus are filed alleging that a person has been picked up or arrested by the army or police authorities and are not traceable thereafter, or has been killed in fact encounter or tortured to death in custody. In such cases, when it is shown that the person detained was last seen alive under the control and command of detaining authority, the burden is on the state to satisfy the court that the person taken into custody has been released. If they fail to do so, the courts in a proceeding under Article 32 or Article 226 may award compensation and exemplary costs to the relative of the victim by way of public no remedy based on strict liability for contravention of fundamental rights. Now, let us come to conclusion. Protection of the right to life and personal liberty is a fundamental duty of every democratic nation. Our country also zealously protects the rights of detainees by providing constitutional as well as statutory safeguards. The courts have recognized the liability of the state to pay compensation when the right to life and personal liberty guaranteed under Article 21 of the Constitution had been violated by the officials of the state. Finally, the fundamental rights enshrined in the Constitution are non-derogatable and their enforcement is a fundamental right itself. Thank you.